process.
Stop. The learned counsel submits that bail is being sought by the petitioner on the ground that Section 41 and Section 42 of the NDNPS Act has been violated. Stop further. There was no civilian witness while the contraband substance was seized. Next para. In view of above, issue notice returnable by 1 week should do. Returnable by, give a date, 1 week. Today is 10th, isn't it? 17th of June. Ms. Mary L. Kiangte, learned additional PP, accepts notice on behalf of the state and no further notice, no formal notice is required. Petitioner shall furnish the copy of the bail application if not already done. List accordingly.
Obliged, my lord.
We call item 10.
Item 10.
10.
Item 10.
Yes.
My lord, I seek your lordship indulgence. We have a mistake for looking cost list, my lord. We didn't find the IA. The matter may be taken up Friday, my lord.
Not Friday.
Thursday.
Let it
My
be
lord-
some other day.
I have some difficulties for tomorrow.
Thursday.
Friday may be better, my lord.
You take it next week then, Monday.
Okay.
As paid for by London CGC, this is the matter again on Monday. Give the date, 14th. I'm sorry, 16th. On 16th of June.
Item 12. May it please your lordship.
Yes.
My lord, this IA has been filed for condemnation of 427 days delay in filing the connected revision petition, my lord.
First time?
No, my lord.
Okay. Any objection?
Objections have been
Yes, my
filed.
lord, we have submitted.
You have submitted the objection.
Yes.
So, can it be heard?
My lord.
Yes. Tell me.
My lord. My lord, execution case number 22 of 2020 was filed by the instant respondent. And
Just a minute.
my lord.
This delays for condoning the delay in filing the revision petition.
Yes, my lord.
And revision petition challenges what order? Which order?
My lord, we have challenged the execution order dated 26/9/2023. This is annexed at page number 17 and 9
In the IA or the main?
in the main, my lord. In the
Page
main.
17.
Yes.
What has been directed?
My lord, it has been directed, operative portion is at page number 18A from paragraph number 5. There was a Lok Adalat award, my lord. The Lok Adalat award has also been annexed at page number 14 of the main case. And in the vernacular, my lord, it's more clear if I may be allowed to read.
Execution arises out of the Lok Adalat order.
Yes, my lord. Wherein I have been directed to pay a sum of rupees 1,50,000, and that it was agreed that 50,000 would be paid first, and the remaining 1 lakh will be steps will be taken.
So you had agreed.
So as to pay the remaining. Yes.
You had agreed to pay. What is
Yes.
wrong in this order?
My lord.
Why didn't you pay up?
My lord, if I may read the Lok Adalat order, it's more clear, my lord.
Read.
From the second paragraph, I will read in the vernacular, my lord.
Vernacular.
Yes, page number 14.
Yes, read.
Pudar than chua mate hian in hun chu cheng noi khat singa in pulal tran puya te in lei hi an rem ti a. Pulal tran puya te hian cheng singa pe phot turin an in rem siama he cheng singa hi thlan hi chunga pek turati ani a. Cheng singa pek ve le hian pudar chua mate hian LSC hi pulal tran pui ten hena an pe anga abak cheng noi khathi loan la ka jun thlavela in peturin anin soirema ma se har sana enge mo ompal ani chuan pulal tran pui te hian puda thua mate hi an hrezel anga arem changang lo ani chuan kum sang ni som chungin pek tlak ram tur ni se he noi khathi an la pe theilo ani chuan LSC hi puda thua mate hian an le le theyang. Now as per this settlement order, it is the word is very clear that attempt would be made to, so as to pay the whole amount of rupees 1 lakh within the year 2010. Chungin pek tlak ram tur ni se. Now, my lord, in the execution order, it has also been reflected that attempt was made. However, when attempt was made for paying the whole amount, the same was not accepted by the instant respondent. That is why payment could not be made. Number 18, page number 18, paragraph number 4.
So, in terms of that settlement, parties are supposed to abide by the settlement.
My lord.
Now, what has happened thereafter?
My lord.
You have not performed your part.
Yes.
Why?
My lord, if I may read paragraph number 4, page number 18, this is the execution order that we have challenged.
See, I was just asking you about the
Yes.
brief background, that's all.
My lord, my lord.
Today we are on the condonation
Yes.
part.
My lord.
First of all, you have a settlement. You don't abide by the settlement. The opposite party has to file an execution.
My lord.
Once they file the execution, you come belatedly after 427 days.
My lord.
What is your explanation?
My lord, before coming to this honorable court, we have inadvertently filed a revision petition before the district and sessions
When?
court, my lord.
Date
This
of
is-
execution, order passed by the execution court? What is the date?
26/9/2023.
26/9,
Yes.
2023.
Yes, my lord. If your lordship could kindly come to
Then,
page.
date of filing your instant revision petition,
This is on February this year, my lord.
date? 24 February.
My lord.
So it's between these two dates.
My lord.
Now,
Bef-
you said you had filed some
Yes.
revision petition before the trial court.
Yes, my lord. It
What
is
was that?
Annexure number 1, page number 11 of the IA. Page number 11. Since there was a delay in filing the said revision before the trial court, my lord, we have filed this CMA 562 of 2024. For
How much delay?
46 days delay.
Even there also is
Yes,
delay.
my lord.
Here also delay, there also delay.
Yes. The
This
case of
doesn't speak very well of the petitioner.
the case of the petitioner is that, my lord, the applicant herein is that he is a unskilled laborer who is working in the construction site. This I have stated at page number 5.
Just a minute. Civil revision petition number 23, is it?
My lord.
Trial court or 3? Is it 23 or 3?
23, my lord. 23,
23 of 2024.
my lord.
Filed on?
This was filed on 28 June 2024.
28 June.
Yes, 2024.
Then what about the CMA?
My lord, the CMA, this has not been disposed of. However, we have, liberty was given and the whole revision was withdrawn, and therefore we have come before this honorable court.
No, CMA is not disposed of?
Yes, my lord.
What do you mean by that?
The CMA 562 of 2024 Because the instant
So,
has res- the
If
instant
your
respondent-
CMA is pending, how come you can file this revision petition in the High Court? Is it permissible?
My lord, page number 16, annexure
You
number
file there, you file here also, both places. Is it possible?
page number 16, annexure number 2, my lord.
Hmm?
Annexure number 2, page number 16.
No, you answer my question. Don't keep on showing the pages. Your application for condonation of delay
Yes.
is pending before that trial court.
No, not pending, because we have withdrawn the case.
Say that. I asked you, you
Yes.
said it's pending. Your friend was prompting you, it's not pending.
It's
You are
not
saying it's
pending.
pending. So
This has been
CMA
withdrawn.
number 562
Yes,
of 2024 was filed for delay.
yes.
How many days?
There was a delay of 246 days.
246.
Yes,
So delay was not condoned.
not condoned.
Before it was condoned, you withdrew it.
Yes.
So where is your order of withdrawal?
Page number 16. Page number 16, annexure number 2. Order dated 29/01/2025.
What was the reason for withdrawing?
My lord, we have, the instant applicant has realized that he had approached the wrong forum.
Why? How?
My lord, section 115 of the CPC.
115, we know what is 115. So,
If I may be allowed to read, my lord, revision. Power of the revision is on the High Court, my lord.
under what provision did you file the revision petition before the trial court?
My lord, in the trial court, 115 only.
115.
Yes,
Here also 115.
yes.
So read 115.
The High Court may call for the record of any case which has been decided by any court subordinate to such High Court and in which no appeal lies thereto. And if such subordinate court appears, A, to have exercised a jurisdiction not vested in it by law, or to have, B, to have failed to exercise a jurisdiction so vested, or C, to have acted in exercise of its jurisdiction illegally or with material irregularity. The High Court may make such order in the case as it thinks fit, provided that the High Court shall not, under this section, vary or reverse any order made or any order deciding an issue in the course of a suit or other proceeding, except where the order, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceedings.
So under 115, you filed revision petition there
Yes, my lord. How-
without reading this provision.
My lord, I have been engaged only to appear before this honorable court. I was not the counsel who was.
I know, you were not the counsel,
My lord,
but today you are stepping in the shoes of everybody.
my lord,
You are the applicant, you are the revision petitioner.
my lord,
Question has to be put to you only.
my lord.
Tomorrow you will file one petition in the lower court with under Article 226. Then later on you'll realize, no, this is not the right forum, they'll come back here. Before you invoke the section, at least you could have read, isn't it?
My lord.
So that was not done. That's
Not
why it was withdrawn.
Yes, my lord, exactly.
So this does not, so what benefit you'll get going to the wrong forum?
My lord, I will be covered by section 14 of the Limitation Act, my lord.
Section 14.
Yes.
What does it say? Yes, please come and help me. The Limitation Act. Section 14.
Yes, my lord. 14.
Time spent for approaching the wrong forum.
If I may read, my lord.
Just a minute. You filed your revision petition on 28/6/24
Yes.
in the lower court.
Yes.
Then you withdrew it on 29/1/2025.
Yes.
After about 7 months.
My lord. My lord,
Wh-
prior,
when did you realize that you have approached the wrong forum?
my lord, we have realized this on January this year, my lord.
After they filed the WO? Opposite
No,
party
they
filed-
have not filed their WO in the trial court. No
See,
WO
Section
submitted.
14 of the Limitation Act has a one particular word
Yes,
which is important. It says bona fide.
my lord.
Suppose you just go and file like that without even bothering to see what sections are there, then you come back and say that, oh, I made a mistake. Can it be called a bona fide? Exclusion of time for proceeding bona fide in court without jurisdiction.
My lord.
So where is your bona fides? You have to show that. With due diligence, you had thought that we could file one revision petition before the lower court against the order of execution. Then, after that, you realized that it's not possible to file a revision, then you came here. Where's your bona fides? These things are to be carefully raised in your application. Have you stated anything? Where have you stated about Section 18 in your, Section 14 in your application?
In paragraph, page number 5, paragraph number 2, sub-para Roman 3, the operative portion is from page number 6. Page number 6 in the last sentence. Fifth line from the bottom of the first paragraph, my lord.
Page number 5.
Page number 6 is the operative portion, where I have mentioned section 14.
Page number 6.
Yes.
So you're just saying that invoke Section 14, but the ingredients is not there. You have the Limitation Act with you?
Yes, my lord.
Read the heading, Section 14, what does it say?
Exclusion of time of proceeding bona fide in court without jurisdiction.
Yes.
Yes.
Where's your bona fides?
My lord, it was my humble belief that I have approached the correct forum.
That is your submission orally. Where is it in writing? It's not there.
My lord, if your lordship could,
You may write one sentence and substantiate orally in 10 sentences. That is not possible.
if I may,
It should be here in your application.
it's at the same paragraph only, my lord. Page number 5, sub para number 3. If I may
Read.
That after much deliberation, the counsel for the applicant realized that they have approached the wrong forum in seeking relief under section 115 of the Civil Procedure Code 1908. The counsel for the applicant submitted an application for withdrawal of the revision petition under order number so and so.
So, that much only. You realize
Yes.
that's all.
Yes.
What took you so long to realize? 6 months, 7 months? Provision you have invoked is strictly meant for the High Court, before the High Court.
My lord.
So on what basis did you have?
And
Anyway, now let us go from the beginning.
My lord.
What is the period of limitation for filing revision?
My lord, 90 days.
90 days. And you have taken delays for
4 to 7 days.
4 to 7 days.
Yes.
So, from 26/9 to 29/1,
My lord.
after withdrawing on 29/1,
Yes.
you have filed it again after about 1 month.
My lord.
What is the explanation?
My lord, explanation is that since the instant applicant was of limited financial means, my lord, he had sought for an advocate who could appear on his behalf as a pro bono. So, my lord, when we were approached, we wasted no time. We have spent a few weeks in collecting the connected materials. We have received instructions on 4th February 2025, and accordingly in the same month only, my lord, we have filed the instant revision petition.
Don't explain about yourself. You are
No.
only an agent of the applicant.
My lord,
You're stepping on the shoes of the applicant.
my lord,
So you have to speak for yourself,
my lord.
not as a counsel. Read from paragraph 2, subpara 1. Page 3.
Yes, my lord. That after the order dated 26/09/2023 was passed by the executing court, the applicant petitioner inadvertently approached the court of the district and sessions judge and filed civil revision petition under section 115 of the Civil Procedure Code. The same was also registered as civil revision petition number 23 of 2024, number 2. That it may be mentioned that civil miscellaneous application number 562 of 2024 was filed with an application for condonation of delay of 246 days in filing the said civil revision petition number 23 of 2024. The reasons for delay in filing the connected revision petition is that the applicant plaintiff was never made aware of the fact that an order dated 26/9/2023 had been passed. The applicant petitioner became aware of the order dated 26/9/2023 only in the month of December 2023. It may be stated that the applicant petitioner was represented by a legal aid counsel before the execution court.
Okay, please stop there. You were represented in the execution court.
Yes.
How come you say that you don't know about the order? How is that possible?
My lord, we were not informed by my legal aid counsel.
Did you file your WS objection to the execution? You don't know?
No, my lord.
Yes or no? Did you file or not?
That I don't know, my lord.
You should know it. That is important. Did he file the
My lord,
objection?
Yes, my lord.
My lord, I
They-
have
Yes.
filed, my lord. I apologize. I have filed. I have also stated in my.
So that means you are
Yes.
aware. Execution case file, you file your objection, whether it's a
Yes.
legal aid counsel, whether it's a private counsel, whatever it is. You were represented before the execution court.
Yes.
Can you take the excuse that I did not know about the order? It's not believable. And secondly, you came to know about the order passed in September, in the month of December.
Yes.
If you come to know about the order passed in December, then why did you file civil revision petition in the lower court again in June, in the month of June 2024?
My lord, that,
After 7 months,
yes. My lord, that explanation has been given in the
you
continuing
better have a proper explanation.
Yes,
Let us
in-
see what is the
in
explanation.
In the continuing paragraph. Since the applicant petitioner had financial difficulties, he was searching for an advocate whom he can engage on pro bono and at a minimal fee. It was only in the month of January 2024 that he had managed to find an advocate who was willing to take up the case considering their lack of finances. That copies of all related documents were obtained in the month of February 2024, that on 21/3/2024, his counsel had informed him that he will not be able to pursue his case in the district court, that the applicant petitioner is a daily wage worker, and he was working in a construction site as helper in the month of April, and as such, he cannot pursue the case.
Huh? Applicant is a construction worker, fine. But what about his counsel?
My lord,
Why could he not pursue the case?
that,
Where is the explanation?
my lord, this is the reason best known to the said advocate, my lord.
Huh?
This is reason best known to the advocate, my lord.
Better we'll dismiss it then.
He has not informed.
He doesn't want to disclose anything, we'll dismiss it. That's all. He says he's got his heart, he doesn't have the finances. Okay. But in January
Yes,
2024,
yes,
he managed to convince a counsel
yes.
to engage him. Then suddenly in February, he says that counsel cannot appear. What is the reason?
His counsel has informed him that
What is the reason?
He would not pursue his case.
What is the reason?
My lord, if I may
There
be,
has to be a reason.
yes,
Today you take a case, okay, I'll take up your case. Tomorrow I cannot take your case. What could be the reason? At least some, you have to at least make some story,
my lord,
believable story.
my lord.
What is that?
If I may be allowed to file an additional affidavit, my lord,
Why should we allow it?
at this stage, my lord.
You think you'll draft one, two, 3 pages condemnation application and court will condemn it like that? It may be for 15 days also, we may not condone it
My lord.
unless you give an explanation. Days, number of days doesn't matter, so long as you provide some plausible explanation. Isn't it?
My lord.
That's what I've been trying to tell you right from the beginning. The approach is very casual. Oh, I went to the wrong forum. I've come now to the right forum. Please condone. I'm very poor. Somehow I engaged a lawyer. Later on he gave up. Why he gave up? No explanation. See, we don't have to tell you what is to be done. You know better.
If your lordship may kindly grant me the opportunity to file additional affidavit.
Why
my
should we give you that opportunity? There is no question of having a trial run. First, let me file one application, let me try. If it is convincing, okay. If it's not convincing, I'll file one more. We'll not allow that. When you do something, you have to do it properly. Please read paragraph, page 5, continue, second paragraph. Let us see what kind of explanation awaits us.
That in the month of May 2024, the applicant petitioner met another advocate who was willing to take up the case on pro bono. And the applicant petitioner handed over the brief of his case to the new counsel on 04/06/2024. There were certain technical elements in connection.
Oh, just a minute.
Yes.
Where is the link here now? May you find somebody and after 2 months you hand over the brief. How can that be? Yes. Read.
There were certain technical elements in connection with the case, and after extensive research, the revision petition was filed on 28/06/2024, before the District and Sessions Judge, Aizawl District. It may be humbly submitted that the applicant petitioner is a daily wage worker, and as such, it is not practical for the applicant petitioner to regularly pursue the instant case, as the same would mean loss of daily wage.
What does it mean? If he pursues his case, he will lose money.
My lord, he has to earn his living by daily labor, my lord.
Let him earn. Pursue has to be done by the lawyer. Does he have to be with the lawyer every day, throughout the day? While drafting, he will be there. While submission also, he will be there. Once you engage a counsel, he will do the works.
My lord.
You go and do your work, your daily earnings. It is not practical for the applicant petitioner to regularly pursue the instant case, as the same would mean loss of daily wage. That means you also want to be a lawyer. When I say you, I mean the applicant.
No, my lord.
He's a daily
No,
wager,
no,
he
no.
also wants to become a lawyer.
And that is not
Then-
the case, my lord.
The way you have worded your
The-
submissions, I think it's quite, doesn't make any sense.
My lord, this basically means that the day spent on approaching an advocate will mean that the wage on those particular days will be lost, my lord.
If you continue reading again, this also, now you have made some statements here which just confuses everybody. Please read, let us see. Paragraph 3.
Paragraph 3. That after much deliberation, the counsel for the applicant realized that they had approached the wrong forum in seeking relief under Section 115 of the Civil Procedure Code 1908. The counsel for the applicant submitted an application for withdrawal of revision petition under Order 23, Rule 1, Sub Rule 3 of the Civil Procedure Code 1908. Accordingly, by the order dated 29/1/2025, the revision petition number 23 of 2024 was allowed to be withdrawn. At this stage, it may be worth mention that the application for condonation of delay was yet to be disposed of. As such, it is a humble prayer of the applicant that the period up to 29/01/2025 may be condoned by invoking the provision of Section 14 of the Limitation Act 1963.
Supposing we accept, we condone up till 29/1/25.
My lord.
Does it serve any purpose?
My lord, after
As prayed for you,
my lord,
supposing
yes,
we condone the delay up till 29/1/2025,
My
does
lord.
it serve your purpose?
my lord,
You have filed the instant review petition, revision petition in February 24th. So the gap between 29 January and 24 February still remains.
yes, my lord.
So
This explanation has been given
this is a
from
unnecessary statements you've made here.
reason for
Since you have withdrawn your revision petition along with the condonation of delay filed in the lower court,
yes,
the delay has to start from day one,
my lord,
from 26/9/2023, up till the
Right.
date of filing your revision petition before the High Court.
yes.
That gap,
exactly, my
the
lord,
entire gap will have to be looked into.
my lord.
Only thing you can mention is that in view of Section 14, please condone the delay which I have spent in approaching going to the wrong forum.
My lord.
That much only. You should take due care in drafting the condonation application, because the entire case hangs on this only. If your application goes, nothing remains. Even if you have drafted a very, Even if you have drafted a very good revision petition, no use.
my lord.
If your delay application fails. So you should take due care in drafting your delay application, continuation of delay application. And what is the authority you have? Don't take out that Lipo Cow thing again.
I have cited.
Everybody has a favorite
Yes, yes.
judgment, Lipo Cow.
Yes.
State of
2000,
Nagaland. Huh?
2024 SEC Online SC 482. Purni Devi and another versus Babu Ram and another. This speaks about Section 11, my lord. Section 14 of the Limitation Act.
I hope there's nothing written about bona fide. If something's written about bona fide, you have not shown any bona fides.
My lord. If your lordship could kindly come to paragraph number 30.
Purni Devi
Yes,
versus Babu Ram.
my lord.
Paragraph number?
Number 30.
Yes.
If I may read. The principles pertaining to applicability of Section 14 were extensively discussed and summarized by this court in Consolidated Engineer Enterprise Supra, wherein, while holding the exclusion of time period under Section 14 of the Limitation Act to a petition under Section 34 of the Arbitration Act, it was observed. 21. Section 14 of the Limitation Act deals with exclusion of time of proceeding bona fide in a court without jurisdiction. On analysis of the said section, it becomes evident that the following conditions must be satisfied before Section 14 can be pressed into service. Number 1, both the prior and subsequent proceedings are civil proceedings prosecuted by the same party. Number 2, the prior proceeding had been prosecuted with due diligence and in good faith. Number 3, the failure of the prior proceeding was due to defect of jurisdiction or other cause of like nature. Number 4, the earlier proceeding and the latter proceeding must relate to the same matter in issue, and both the proceedings are in accord. Paragraph number 37. Paragraph 37.
Yes.
No substantial averment has come on record to substantiate that claim that the predecessor in interest of the plaintiff approached that tacitol with a malified intention in the absence of good faith or with the knowledge that it was not the court having competent jurisdiction to execute the decree. The object to advance the cause of justice must well be kept in mind. My lord, in this instant case, the Honorable Apex Court had condoned the delay from the period 18/12/2000 to 29/01/2005.
You have just read that paragraph 30,
My lord.
which quotes the
Yes.
judgment rendered in Consolidated Engineering Enterprise,
Yes.
paragraph 21. 21 subparagraph 2. The prior proceedings have been prosecuted with due diligence and in good faith.
My lord.
This is very important.
My lord.
It took you about 7 months to realize that you have pursued the wrong forum. How is that possible? Any other judgment?
My lord, I have that Lipok Au's judgment, but
Yes, show us. Don't hesitate.
my lord, my lord. 2005.
Basically, it's about governments. Lipokau.
Yes, basically.
Government of Nagaland had some delay in filing,
Yes.
some movement of files and all that. Which paragraph?
Paragraph number 12.
Read.
In OP Katpalia versus Lakshmir Singh, a bench of 3 judges held that if the refusal to condone the delay results in grave miscarriage of justice, it would be a ground to condone the delay.
So instead of quoting Lipok Au, you should have straight away quoted this OP
My lord.
Katpalia. This is in 1984, volume 4, SCC. So only that you want to rely?
Yes, my lord.
Paragraph 12.
Yes, only that.
Okay. Miscarriage of justice.
My lord.
Now, how do you explain miscarriage of justice in your case?
My lord, for that, I will have to enter into a little bit in the merits of the case, my lord. Because the trial court has misinterpreted the award passed by the Lok Adalat.
Misinterpreted?
Yes.
How?
Because, my lord, at page number 16 in the main case, it is written that if at all it is, if there is any problem, arising out of payment of rupees 1 lakh, Sri Laltanpui will inform Sri Darthoma immediately. If at all it is not possible, payment may be made prior to expiry of 2010. Now the word here is maybe. However, and I have filed my written objection in the execution proceedings, and I have stated that I have made an attempt to pay the remaining rupees 1 lakh to the instant respondent. However, the respondent refused. Attempt was made, my lord, on my part. Attempt was made on my part for repayment of the said money.
Only that?
Yes. However, the same was not accepted by the instant respondent.
So now you say that you have filed an objection in the execution case, whereas you say that I do not know about the disposal of the execution case.
My lord. Because I was not informed, my lord.
So it's rather strange.
I was not informed until
You
December.
are also supposed to inquire.
Yes. My lord.
You engage somebody and you forget about your case. Shouldn't you ask also occasionally what has happened to my case? Anything? Any developments? You cannot just ignore like that.
My lord.
Yes. Anything else?
No, my lord, that is all, my lord.
Okay. Mr. Murmu?
Yes, my lord. My lord, as per my calculation, the delay period from the execution order 26/9/2023, my calculation is 516 days, not 427 days.
516 days.
Yes, my lord. From the
From?
counting from 26/9/2023
Up to?
up to 24/2/2025, filing the instant application.
Okay. Have you deducted the limitation, the period of period of limitation prescribed, 90 days?
Yes, no, I have not cut that part.
Are you not supposed to cut it or,
Yes, I have to
or
cut my
deduct it?
Yes, I
Then?
have to. So, my lord, my objection is in my para 4, from para 4. The instant applicant has failed to explain about.
Mr. Murmu, let us get things straight first.
Yes, my lord.
He says 427 days. What does the registry say? They have not calculated. I don't know. I have instructed the people to calculate. They will say 10 days, you will say 10 days. You have to see whether it's 10 days or not, like that. Anyway,
Yes, my lord.
he says 527, you say 516. Why is the difference? Difference because you have not deducted 90 days. You are supposed to deduct that.
Yes, I will.
Okay.
Yes, my lord.
So don't simply submit like that, these 516 days.
Yes. But still, my lord.
You have to add one line saying that without deduction.
Yes.
With deduction, it comes to 526 or 527.
Yes.
So that is okay, isn't it?
Yes, my lord.
Then, next.
My submission is that, my lord, the applicant explanation regarding the cause of delay is vague and concocted one.
Why?
Because he has knowledge about the execution case and he has she has contested in the execution case as
But
well.
he doesn't have the knowledge about the disposal.
But still, my lord, she has to inquire
Okay.
because the execution case is filed on 2020 and it's pending for long period. And the execution order is passed only on 2023. So she have to inquire what about my case and what is the progress of the case. That's all. So her explanation regarding this has not been shown in their application. She said that she simply said that she came to aware of the order only in the month of December 2023. But she failed to explain a period between 27/9/2023 to 15/12/2023. I counted 15/12 as a middle of the December when she came to know about the
27/9/23 to
15/12/2023, 15 December 2023. 75 days. She slept over.
No,
She did not-
explanation
she
is that
disregard. Yes, madam.
applicant is she or what, or he?
They are represent she, my lord.
Okay. The applicant does not know, says that she does not know about the disposal of the execution case.
Yes.
That's why from the date of disposal of the execution up till December,
Yes. But
she has no knowledge.
Yes, she doesn't explain why she doesn't know about the order. She have to inquire to her counsel whatever the progress of my case.
She says she does not know about the order passed. You say that she still has to explain why she does not know.
Yes.
That's what you say?
Yes, my lord.
Okay.
And
Then,
my lord, the applicant remain ignorant and does not take any action prior to the expiry of the limitation period. She came to know about the order only on, as per her statement, only on December, but she doesn't take any diligent action to pursue her case. And she failed to explain that as well. So it cannot be condoned. And after that, my lord, she stated in her application that she managed to engage an advocate only in the month of January 2024, and the related copies of the order and the case has been furnished to the advocate only in the month of February 2024. Between these 2 months, she failed to explain what has she done to pursue her case. It takes 1 month around. And she stated that she obtained related copies of the execution case, but she never stated that what related copies and from where do she obtain. So her statement doesn't corroborate, as well as there is no material evidence to show her, to corroborate her statement. Further, my lord, she failed to explain another 40 days delay for the month of March to April, that is 21/3 to 2024, when the council, first council, which she alleged to find, fails to pursue her case. She find she find another advocate, but she fails to explain the period between 21/3/2024 to 30/4/2024, March and April period, 40 days. And in her statement, she stated that she made with another advocate who was willing to take her case, and she handed her case only in the month of June, 4 June 2024. So she failed to explain another 30 days from May to June, 4th May 2024 to 4th June 2024. She fails to explain about what she has done and to pursue her case. So, my lord, her explanation is a very vague and very concocted one. And my lord, regarding the execution case, the lower court, which they filed allegedly which they think that they have filed inadvertently. In that one also, my lord, I have one submission that they came to know about the jurisdiction of the section 155 revision only after the instant respondent filed the written objection in the lower court. Before that, they haven't take any action, or they haven't any research about the provision. They only came to know when the respondent filed a written objection, and she pointed out in the written objection that this provision is wrong, and that is wrong. And
When was that? You have a copy of that objection?
yes, my lord.
When was it filed?
My lord, I have only the copies of the written objection. I don't know when it was filed. 13 November 2024, written objection in the lower court. 30 November 2024. Yes, my lord, 1-3. 24, my lord. Yes. Yes. So I didn't accept their statement that they, after due deliberation, they came to know about that they have approached the wrong.
Objection.
Paragraph 7.
So at paragraph 7, you have stated that revision
Yes.
is not maintainable.
No, my lord. In paragraph 7, I said that they stated that they have realized that they have approached the wrong forum.
No, I'm asking about your written objection.
Yes.
In which paragraph did you mention that revision is not maintainable before the lower court?
Paragraph 7.
Read.
That with regard to the averment made in subpara 3 to subpara 6 of paragraph 2, the answering respondent would like to state that the counsel for the applicant / petitioner realized that they approached the wrong forum only when the answering respondent has pointed out in her written objection.
Oh,
Of
I'm asking you to read the written objection in the lower court, not
sorry,
before this
my
high court.
lord. I'm sorry.
In the execution. I'm sorry, in the revision petition.
Revision in the lower court, yes, my lord.
Where have you stated that? Your written objection was
Yes.
filed on 13/11/2024, you say.
Yes, my lord.
Okay, where have you stated that? In which paragraph? Please read.
In my written objection,
Paragraph number?
my lord,
You have not stated or what?
no, my lord.
Then what?
I didn't
Then why did you
state
make
it.
that submission? If you have not stated that, why did you make that submission? That they have come to learn about this only after we made an objection. From where have you made that submission? Show me a copy of your objection.
Para 8, my lord.
See, paragraph 8, you have mixed up between 115 and section 5. So this is not an objection about the maintainability of the civil revision petition. You're talking about something else, Limitation Act. Have you filed any objection on the civil revision petition itself?
Sorry, my lord.
Did you file any objection in the civil revision petition before the trial court?
No,
You have not filed.
no.
Only objection in the limitation,
Yes.
condonation of
Because
the
they have withdrawn.
Yes, then what else?
Yes. So, my lord, the explanation which the applicant showing herein is vague and concocted, as I earlier said, and she remained in action and ignorance about her case and doesn't show any sufficient cause for condonation. So, I pray that this honorable court may dismiss the application. And my lord, I have some authorities to rely upon.
Yes, what is that?
My lord, first one, I would like to rely on Supreme Court 2023.
Yes, madam, you are a lawyer?
My lord, it's on page 15.
31, yes.
Yes, if I
31, yes.
yes, if I may read, my lord.
31, yes.
Yes, if I may read, my lord. Sometimes due discretion in favor of grant fair for condonation would be the question. Law is fairly well stated that a court of appeal should not ordinarily interfere with the discretionary exercise by the court below, NASA, which in turn relied on the decision in Gujarat Steel Tube Limited versus Gujarat Steel Tubes Mazdoor Sabha, wherein it has been held that an appellate power interferes not when the order appeal is not right, but only when it is clearly wrong. So, my lord, what I am trying to state that the applicant explanation in this instant application is only an excuse, not an explanation, not the sufficient explanation. And another authority which I want to rely is, my lord, 2024 SCC Online SC 3612, State of Madhya Pradesh versus Rajkumar Chaudhary. I want to rely on para 7, page 5.
Yes,
Yes, if I may read.
yes.
There is another aspect of the matter which we must ignore or we must not ignore or overlook. Over a period of time, we have noticed that whenever there is a plea for continuation of delay, be it at the instance of the private litigant, be explained right from the time the limitation start, and if there is a delay of say 2 years or 3 years or 4 years till the end of the same. For example, if the period of limitation is 90 days, then the party seeking continuation has to explain why it was unable to institute the proceedings within the period of limitation. What events occurs after the 91st day till the last is of no consequence. The court is required to consider what come in the way of the party that it was unable to file it between the first day and the 90th day. It is true that a party is entitled to wait until the last day of limitation for filing an appeal, but when it allows the limitation period to expire and plead sufficient cause for not filing the appeal earlier, the sufficient cause must establish that because of some event or circumstance, the sufficient cause must establish that because of some event or circumstance arising before the limitation period, it was not possible to file the appeal within time. No event or circumstance arising after the expiry of limitation can constitute such sufficient cause. There may be events or circumstances subsequent to the expiry of limitation which may further delay the filing of the appeal, but that the limitation has been allowed to expire without the appeal being filed must be traced to a cause arising within the period of limitation. This adjustment has been relied on Ajit Singh Thakur Singh versus State of Gujarat 1981, 1 SCC 495. So what I'm stating is that they have failed to explain. She has contested in the lower court, but she failed to explain where was she and what does she do to pursue her case with due diligence. So this application, the statement made in the application are the concocted one and mere excuse, not an explanation. So I pray that this honorable court dismiss the instant application.
Yes, Mr. Zekima, anything?
No, my lord.
All right. We'll do one thing. I'll rise for 5 minutes and come back. We'll dictate the order. Call the Jamadar.
My lord, if I may be allowed to make just one submission, my lord.
Yes.
My lord, this instant revision petition has been filed because the executing court had wrongly interpreted the order passed by the Lok Adalat. And that Lok Adalat order dated 18/5/2010 has not been challenged, my lord. So, my lord, if your lordship could kindly consider this point, my lord.
You had your chance before the executing court, isn't it?
My lord.
You had your chance to
Yes, I
project your case.
yes I have. I had. However, the the order passed by the Lok Adalat, my lord, in our humble opinion, and that is why we have come before this honorable court. Is that
How you say it's wrongly interpreted?
because, my lord, the word in the Lok Adalat order is very clear that if possible, attempt will be made that repayment of the said.
Okay. Let us see once again your Lok Adalat.
Page number 14, and example number 1 is in the vernacular.
What gave rise to this Lok Adalat issue? What was the background? What is the background?
My lord, there were two land passes. We were the land passes of the parties herein are immediately adjacent to one another.
Yes.
And
then?
that after I was issued the land pass, the respondent herein was also issued the land pass, and
Okay.
that land pass had encroached upon my land. However, since there was a valid land pass that was also being issued by the same authority, by this order, I was set to give the respondent a sum of rupees 1,50,000. And that I will have that piece of land that has encroached upon my piece of the respondent's land that has encroached upon my land. However, since I am unable to repay the said rupees 1 lakh rupees, then I have been directed by the execution order to vacate my land. Madam.
So it is regarding the timeline.
Yes,
According to you, there is no timeline fixed.
yes,
Well, Lok Adalat has given timeline.
yes, my lord.
So what is wrong in that?
My lord, because here it says that an attempt will be made, may be made, my lord. It is even more clear in the vernacular. And I was not able to,
Which part? Just read again that
page number 14,
attempt part. Where is that? Which line?
third line from the bottom.
Read.
Arem changang lo ani chon kumsang ni som chungin pek tlak sham tur ni se sham the word.
Okay, so
Yes. And
within 2010 you have to
Yes.
pay. That's all.
yes, and since I was unable to pay within this 2010, however, I have made an attempt to make the repayment thereafter, and that has, however, the instead respondent has refused to accept the same. This fact I have stated in my objection that I have filed in the execution case, which has also been reflected at paragraph number 4.
4 of?
4 of the impugned execution order, page number 18. Page number 18, paragraph number 4. I have, not only on one occasion, my lord, I have tried to make
But this
payment.
is in the month of June 2010. When did you make the attempt to pay? When did you make the attempt
My
to
lord,
pay?
my lord, I have made attempt in the month of June, my lord. Lok Adalat
Of which year?
Lok Adalat order is 18/05/2010.
Okay. June of which month? I mean, which year?
2010, my lord. 2010.
2010.
Yes.
So,
However,
the order also
Is it-
says that you
Yes.
should pay, you should try to make an attempt to pay the entire thing within
yes.
2010, the year
Yes.
2010.
However, when I approached the respondent, my lord, somehow he has not accepted. He's refused to accept the same.
What is your name?
Laltan Puya, my lord.
You are supposed to buy some land from Dartuama,
My lord.
correct?
My lord.
For an amount of rupees 1,50,000. You will pay in advance of 50,000. Have you paid? 50
Yes, that has been paid.
Which shall be paid within 2 months. That you have paid.
Yes.
After the amount of 50,000 is paid, Mr. Dartham will hand over the LSC.
Yes.
LSC is given to you?
My lord.
Given to you.
Yes.
It is also agreed that Lal Chanpuya will pay remaining balance of 1 lakh in June from loan which will be taken by him. So you are supposed to pay in June. Have you paid that?
I have made an attempt to pay. However, the
When?
My lord, this has been reflected at paragraph 14 of the impugned order. Paragraph 4 of the impugned order. It has been stated that,
Read.
yes, judgment debtor through his counsel submitted written objection to the execution application and stated inter alia that judgment debtor's wife and his daughter twice tried to pay up the money as per a word of the Lok Adalat in the month of June 2010. However, on both occasions, the decree holder refused to receive the money, saying that he would have a discussion first with his family and
Okay.
inform the judgment debtor. Yes.
So Lok Adalat award says that it is agreed that Lal Chanpuya will pay remaining balance of 1 lakh in June, which you attempted
Yes, my lord.
twice,
Yes.
for the loan which will be taken, from the loan which will be taken by him.
Yes.
If there is any problem arising out of payment of rupees 1 lakh, Lal Chanpuya will inform Dartham immediately. If at all it is not possible, payment will be made prior to expiry of 2010.
Yes,
So you are supposed to buy that land from the opposite party
my lord.
for a sum of rupees 1 lakh
50,000.
50,000.
Yes.
That is the overlap portion.
Yes. I have made payment of rupees 50,000.
No, for what? For the overlap portion?
Yes, my lord. And for the overlapped as well as in the overlapped portion, this LSC has been issued, my lord.
Which LSC? LSC issued to whom? To you?
To the respondent hearing.
LSC is issued to the respondent, and why should you pay?
Because since his land had encroached, that portion of LSC has encroached upon my land, it was agreed by in the Lok Adalat that I will give him a sum of this rupees 1,50,000, and in return he will hand me over the LSC, and
It is the other way around, isn't it? If you have encroached somebody's land, you have to pay. Now instead, you are paying. Somebody has encroached your land and you are paying them.
this is as per the award, my lord.
So that is,
Yes.
you have accepted the fact that the land encroached, the LSC which encroaches to your land is not your land. Who is at default? You or the other person?
My lord,
You are at default.
the other person, my lord.
Then why are you paying then?
Because, my lord, we have come to this settlement.
What kind of settlement is that?
In the Lok Adalat.
What kind of settlement is that?
That I will pay him, and that he will hand me over the.
Somebody comes and steals your shoes, you pay that person also. Extra, take this money also. Like that.
My lord, this is as per the Lok Adalat.
It is as per the Lok Adalat, but what kind of order is that? It is very strange. You are saying that my land is overlapped by your neighbors, and instead of him paying you, you are paying them. Which means that you are accepting that you are at fault. Now, what has the execution code said?
My lord, the operative portion is
You hand back the LSC. What does it say?
page number 19, paragraph number 6. In view of the above, the execution petition is allowed inasmuch as the decree holder shall immediately take repossession of LSC number so and the judgment debtor shall forthwith vacate the landed property under LSC number so and so.
So? Have you constructed anything there?
I lived in the in the residential building within this LSC, my lord.
Which is constructed in LSC?
My lord.
That means you have encroached, not he has encroached, you have encroached. So why do you say that this is not,
My lord,
the execution order is not in terms of the order, Lok Adalat order?
because my lord, I have made an attempt to comply with the order of the Lok Adalat. However, that has been not accepted by the respondent. I have made an attempt twice.
Mr. Murmu,
Yes, my lord.
what do you say in this? You have made a settlement before the Lok Adalat.
Yes,
That first of all, he'll give you 50,000.
yes, my lord.
Later on, he'll obtain loan, and
Yes.
from there, he'll give you 1 lakh.
Yes,
50,000 immediately you have received.
yes,
Thereafter, in the month of June, he and his daughter,
My lord, my wife and my daughter.
wife and daughter, tried to give you 1 lakh. You refuse.
no, my lord. Why should I refuse?
But that is what is recorded here in the impugned order. Paragraph 4 of the judgment, impugned judgment.
Yes,
Can you show me the objection, written objection, which you filed before the execution court? Is it available anywhere in the record?
My lord, the trial court's record has not been called, my lord.
It may not be called, but don't you have it in your file?
No, my lord.
Then on what basis you are submitting then?
On the
Merely
basis-
showing me the judgment,
On the basis of the impugned judgment, my lord.
which is under challenge.
Yes.
So how can we accept this, which is under challenge again? You should be able to demonstrate before the court that this is what I submitted before the executing court. This is my objection. You cannot even show that, and you're coming and making your submission like that. You don't have a copy? Are you
No, my
sure?
lord. My lord. And my lord, it has been even reflected that my willingness to pay as before the executing court, that my willing to pay has also been reflected at page number 19.
You should be able to show me by giving me that copy. You produce tomorrow.
My lord,
We'll see.
my lord.
List again tomorrow.
Deeply obliged.
Please come.
Item 13.
You first come before calling the matter. Hey, file is for the law. See, this judgment you get a printout from the library, Lipoka, whatever, okay? Okay. return this to Mr. Murmu. Yes.
My Lord, I'm the claimant before the London Tribunal, and I filed this IA for a release of the deposited amount, which was deposited by the appellant insurance company.
How much?
They've deposited 23 lakhs,
What is that, 50%?
50% of the awarded amount.
What do you say?
I have filed my objection.
You have filed objection?
Yes, stating that this
You are the
may-
claimant
I'm the claimant, my Lord.
and you are
I'm
the
the insurance-
appellant.
Yes.
You are the appellant.
Yes, yes.
What is the ground of your challenge?
Ground of challenge is basically on 3 points.
Are you disputing your liability or just the quantum? Which one?
The quantum as well as we have one point saying that it was a case of a drunken driving case. And secondly, regarding quantum.
So liability you have no challenge. It's just the quantum.
Basically.
Where's your appeal? Let's see. It's a case of death.
Death, my
Who
Lord.
died?
My son. I'm the father of the deceased.
No. The driver or who?
The pillion rider, my Lord.
Accident involves one vehicle or two vehicle?
One vehicle, scooty,
Scooty.
my Lord.
The pillion rider expired.
Pillion rider expired, my Lord.
Then the rider of the scooty, is he a party? Who is the owner of the scooty?
The rider of scooty is respondent number 2. And
Is he the owner of the scooty?
yes, and
No.
no, the owner is respondent number 3, the previous owner, and it was sold to the respondent number 4 again, purchased by respondent number 4.
Who's respondent number 4?
The purchaser of the scooty.
Second owner.
Oh, the one who was driving. There were two persons driving that scooty.
Driver is different, owner is different. Owner is respondent 3, driver is respondent 2.
Owner is nowhere in that thing, in the accident.
No.
No.
Somebody else was driving.
Yes, my Lord.
You are the pillion rider.
I'm the pillion rider.
I mean, your son
My son.
was a pillion rider. He expired. And the scooty was insured with your company.
Yes.
And there were two owners earlier. Previous owner
Yes.
and second owner.
Yes. Yes.
Now, your claim of being a case of drunken driving, was that your case before the tribunal?
It was put up
Or you
as-
suddenly came up with that idea in the appeal only?
It was as per after going through the evidence, this drunken driving case has been taken up. But the main ground of appeal is regarding the quantum, as of this stage, because
How much is awarded?
44 lakhs,
44 lakhs.
my Lord.
What was he doing?
He was working in a workshop, carpentry workshop,
Carpentry workshop.
my Lord. He was salary was 45,000 per month, but the London Tribunal had awarded the amount as skilled one labor, that is rupees 730 per day,
Okay. Amount awarded is how much? 44 lakhs.
44 lakhs.
And how much is deposited?
23 lakhs, 50%.
23 lakhs is 50%.
23 lakhs, my lord. Awarded amount is 44 lakhs, and the deposited amount
50,
is
50% will come to 22 lakhs.
it's along with interest, my lord.
Huh?
Yes.
Along with interest, my lord.
Interest is calculated.
23 lakhs deposited.
25 lakhs, my lord. Along with interest.
25 lakhs deposited.
25 lakhs deposited.
31,765.
So, according to you, how much should be paid?
My appeal is on the ground that they have not proved their case, showing that he is a skilled laborer.
Okay, so how much should be paid? Tribunal has awarded 44 lakhs. How much should be paid?
As per the
3,
notional
4
income,
lakhs, 5 lakhs, how much?
as per the notional income, the
How
income
much?
has to be established as per the notional
As per
income.
notional income calculation comes to how much?
The income per month as of the calculated by the tribunal is coming around 12,000 rupees, as calculated on a daily basis of 730 rupees, and then in a month it comes around 12,000 rupees. Now,
21,000.
oh sorry, 21,000 rupees.
21,000.
Yes,
Per month.
That is the notional.
yes, as per the trial court.
No, I'm asking
No,
you as
not-
per
not it is
you.
the notional. It is-
Trial court has calculated 44
Yes,
lakhs.
yes, yes.
You are not happy about it.
Yes.
How much amount will you be happy on? 20 lakhs, 30 lakhs, how much?
As per that notional income, it comes around 6,000 rupees.
So make a calculation. How much will it come to? 6,000 rupees. Will it be more than 25 lakhs, roughly?
Let me calculate.
Calculate. Make a rough calculation. Don't give me that decimal calculation.
Yes, yes, I'll do that.
Mr. Tlantian Lima, how much is deposited? 25 lakhs.
25 lakhs, 31,765.
25 lakhs.
31,765.
This is with interest.
With interest, my lord.
With interest means from the awarded amount is from the date of, interest is awarded from the date of filing.
Date of filing, that is 2022.
From the date of filing up till the date of deposit in the registry, that interest
I believe so, my
on the
lord.
50%.
Yes, my lord.
Is that your application also?
Yes, my lord.
With that figure, 25,
With that
31,
figure, my lord.
375, 365, 765, sorry. Please write down. Heard Mr. Tlantian Lima, learned counsel for the applicant, and Mr. Roshan Subedi, learned counsel for the respondent number 1. Stop. By filing this application, the applicant seeks release of rupees 25, 31, 765, which was deposited by the respondent number 1. Stroke appellant on 13/3/2025 as directed by this court by order dated 23/1/2025. Most of the learned counsel submits that the said amount is 50% of the awarded amount along with interest calculated from the date of filing the claim before the tribunal. Full stop. The learned counsel submits that since the applicant that sentence you write, he submits that. Do not look at, cancel, okay? The learned counsel submits that pending disposal of the main appeal, the said amount may be released to the applicant. Stop. So have you calculated? How much?
It's coming around 13,43,400.
How much?
If
13?
we take 6,000 rupees as a notional income, it comes around 13,43,400 rupees.
6,000.
Yes, as per
Now, as per the tribunal, 12,000.
21,000.
21,000.
Okay.
21,900.
So that
6,000 is notional.
yes, as per 6,000
Okay.
notional income.
Okay.
Because in one of the case passed by the Supreme Court in a vegetable seller case, the notional income was taken around 6,000 only. Because on that basis only I am saying that.
Anyway, we'll release the amount. Full stop. The grounds taken by the appellant, stroke, respondent number 1 in the instant application is mainly on the quantum of the compensation and not on the liability. To stop accordingly, upon due consideration of the materials available on record, registry is directed to release sum of rupees 25,31,765 to the applicant on proper identification and as per the usual formalities. Higher stands disposed of. What about the appeal? Any LCR is required?
Service is not complete.
Not complete.
Yes.
Not complete, my lord. Only respondents 2 to 4 has AD card has not returned, I believe. I'm the respondent number 1 in the main appeal.
See, notice to respondent number 2 has returned answer with a postal note, returned to sender. Addressee cannot be located. So what is to be done? Who is respondent number 2?
The driver of the scooty.
Then what about the others? 2 to 4, none has been served, isn't it?
Yes.
See, even from respondent number 3, it has returned back insufficient address. After that, what happened? You took fresh steps or what?
No.
You did not take fresh steps?
No. I may be permitted to take fresh steps, or otherwise newspaper publication may be allowed.
All right.
Because
In the main appeal, you write, apart from respondent number 1, respondent number 2, 3, and 4 remain unrepresented, and it is seen that notice is not yet served. Full stop. Office note dated 26/5/2025 indicates that notice sent to respondent number 2 has returned back with a postal note, open inverted comma, return to sender. Addressee cannot be located, close inverted comma. Stop. Likewise, office note dated 18/2/2025 indicates that unserved notice received back from respondent number 3 with a postal note, open inverted comma, insufficient address, close inverted comma. Next para. In view of above, appellant is permitted to serve notice upon the respondent numbers 2, 3, and 4 in a substituted manner by making a newspaper publication in one local daily for 2 consecutive days, showing the next court date as July 15th. Full stop. Let newspaper publication be done by routing through the registry of this court within a period of 10 days from today.
I'm obliged.
I'm obliged.
Admission item 2.
Please, Your Lordship.
Yes.
My Lord, I filed this review against the judgment and order dated 13/8/2024, passed in RSA number 2 of 2022. I will not be relying on any citation, just one limited ground that I would like to raise in this, Your Lordship. Just to recap the facts of the case, there was a will executed, executed by the testator, and then thereafter the will was executed in 2014 before the new act came into play. The testator passed away prior to the coming into force of the act as well. But subsequently, the probate was filed in 2015 when the new act came into play. So one issue that was formulated before this honorable court was whether the old act or the new act will be applicable in the instant case. Because the reason being is that the respondent appellant, the present respondent appellant, was appointed as the executor. He is neither the brother or sister, he's not a relative of any of the parties. Now the new act clearly says that the legatee will be the executor. And he's not and the present executor in the present will is not a beneficiary. He's just an executor.
So that aspect of the matter, was it not decided by this court?
Yes, it is on that point that I'm filing this present review, Your Lordship.
So what is there to review?
So, yes, Your Lordship, I'll come to that. Coming to that, the issue was that in the first appellate court, the first appellate court had held that the old act would come into play. However, as the judgment was passed in favor of the present review petitioner, we did not file in an appeal. In fact, it was the respondent who filed the appeal. So, if Your Lordship can kindly turn to page 18. Appeal was allowed, subsequently. Ultimately, the appeal was allowed. The second appeal was allowed. Page 18, Annexure 1. And if Your Lordship can kindly first turn to page 20, para 7. These were the four substantial question of law that was formulated. I will be basically relying on only this point number 1. Whether Zir Liana, the instant appellant, not being the legatee, can said to have locus standi to file a petition to probate the will dated 15/8/2014, executed by so-and-so, and file the subsequent connected appeal in violation of the provisions of the Mizo Marriage, Divorce and Inheritance of Property Act. This substantial question of law was decided by your lordship at page 26, para 21. So my review is limited to only this para 21. May I read, your lordship?
Yes.
I have heard the submission made by the learned counsels for the rival parties, and I have perused the materials available under court. The Act of 2014 came into force on so-and-so date. The will has said to have been made on 15/8/2014, and so-and-so expired on 2/12/2014. The probate application was filed by the appellant on 27/4/2015. The fact, however, remains that when the will was made on 15/8/2014, the Act of 2014 had not come into force. The respondent in the probate case had not taken any objection with regard to the maintainability of the probate application, in view of the Act of 2014 having provided that the legatee will be the executor of the will. The first appellate court in its judgment and order dated 2/2/2021 passed in RFA number 26 of 2014 at para 6 held that the will executed on a date averred would be governed by the Act of 1956. The same has neither been challenged nor objected to by the respondent at any point of time. This apart, the will executed under the Act of 1956, that is prior to the coming into force of the Act of 2014, cannot be rendered to be futile, and that the repeal and saving clause of the Act of 2014 only takes care of this situation. Such being the case, the objection raised by the respondent in this regard will have to be overruled. So, the first aspect is that, your lordship, number one is that my submission before this honorable court on this particular point at para 20, as can be seen, was that the change in law during the pendency of any case will have to be taken into consideration. That is there, my submission. The case law is there. I will not revisit that. Only this aspect, your lordship, just because, number one, there could not have been any question of the review petitioner respondent filing an appeal, because that judgment and order was passed in our favor. The merit of the case was decided in my favor. That's why I would not have any cause of action to file an appeal in the first instance.
Where have you raised that in your grounds?
My lord,
You have taken some grounds at paragraph 10 of this review.
paragraph 10, yes.
Page 12.
Yes, your lordship.
Which is the relevant paragraph?
Yes, second, point number 2.
Point number 2, just read.
For that, this honorable court in its judgment and order dated so-and-so has held that the finding of the first appellate court in its judgment and order dated so-and-so, passed in RFA number so-and-so, to the effect that the will in question in the instant case would be governed by the Mizo District Inheritance of Property Act 1956, and since the same has not been challenged by the review petitioner, the objection at the stage of second appeal by the review petitioner would have to be overruled. In this respect, it may be humbly submitted that the judgment and order dated so-and-so passed in RFA number so-and-so was passed in favor of the review petitioner. As such, there was never any question of the review petitioner challenging the judgment and order dated so-and-so, inasmuch as the review petitioner would lack any cause of action. That is my point number 1, your lordship. And the second point basically is that, your lordship,
You said there you had only one point. Now you say this is only one point. Now point
on
number
the same issue, on the same issue, on the same issue, on this limited to this para 21 only, on this same issue.
Okay.
And the last point that I would like to raise is that, your lordship, even if in the absence of filing an appeal, that would not prevent this honorable court from exercising its jurisdiction to reappreciate the facts in light of Order 41, Rule 33 of the CPC. May I take your lordship to Order 41, Rule 33? Order 41, Rule 33.
23 or 33?
33, 33. Power of Court of Appeal.
Yes,
May I read, your lordship?
yes.
The appellate court shall have power to pass any decree and make any such order which ought to have been passed or made, and to pass or make such further or other decrees or order as the case may require, and this power may be exercised by the court notwithstanding that the appeal is as to part only of the decree and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or objection, and may, where there have been decrees in cross suits or where two or more decrees are passed in one suit. So my basic submission is that, my conclusive submission is that, although we may not have filed an appeal, but this court has sufficient powers under this provision to revisit that issue, Your Lordship.
But we are dealing with second appeal, isn't it?
Correct, Your Lordship.
So the provision which you read is regarding appeal.
Correct.
Doesn't necessarily be a second appeal.
But it says it's still a court of appeal, Your Lordship. It will still be a court of appeal.
No, the basic principles regarding appeal would be the first appellate court would have the jurisdiction to entertain back into the evidence led by the parties and reappreciate the evidence. Whereas in the case of a second appeal, it's always limited to a substantial question of law being involved.
Correct, Your Lordship.
And court may not, by and large, go into the evidence and reappreciate everything.
But
What do you say on that?
But the fact of the matter remains, my lord, my first submission, coming back to my first submission, I would have lacked the cause of action to file an appeal in the first place, because the first appellate court had ruled in favor of me. There would not have been any reasons for me to to file a second appeal, as it was in my favor that was passed. So that is, those are only two limited grounds that I'm raising, and I will not be relying on any citation, nothing like that. Just based on that, those two submissions, Your Lordship, may kindly consider.
Can you just go back to the basic facts? There was a will,
Yes, Your Lordship.
and that will was probated in your favor.
No, it was dismissed,
It was dismissed.
my lord. Saying that since the present executor named in the will is not the legatee,
It
as
was
provided under the new act. That's why it was dismissed.
Your probate application was dismissed.
His probate application.
His probate application was dismissed.
Yes, my lord.
And the first appellate court?
Initially it was probated.
Probated.
Sorry, I apologize. Even
And when you file an appeal,
I filed an appeal.
First
saying-
appeal.
First appeal. That was
probate was cancelled.
cancelled. Then second appeal.
And by the second appeal, that probate has been revived. Revived.
Yes, yes.
Okay. But there's one observation, Mr. Fakoma,
My lord.
which you just read at page 26. Judgment
My lord.
sought to be reviewed. Page 26, paragraph 21.
Yes, Your Lordship.
If you come somewhere in the middle of the page, the middle of the paragraph 21, if you see the extreme end of the right side, on the right side in the middle, the first appellate court,
My Lord.
9th line from the top of paragraph 21,
Yes, Your Lordship.
towards the end of that sentence, the first
The first appellate court.
first appellate court in its judgment and order dated passed in so and so, at paragraph 6, also held that the will executed on the date averred would be governed by the Act of 1956. That means the old Act.
My Lord.
New Act was of 2014. So, this observation and the finding of the first appellate court remains. So, this is what the court had observed in the second appeal.
Right.
This aspect of the matter remains as it is. Court says that 1956 will prevail. That is why we came to the conclusion that it was not challenged and not objected by anybody at any point of time. The will of executed as per 1956 Act prior to the new Act will have to be reckoned. Having regard to the saving clause. Okay, let me hear Mr. Malhotra.
My Lord.
No. May I please, Your Lordship? My learned friend, yes, is,
He's on a very limited point.
yes. Your Lordship, as we can see from para 21, but I'd like to take Your Lordship to para 8 of the judgment, page 21.
Yes.
This is my submission before Your Lordship at the time of hearing of the second appeal. Referring to the first substantial question of law, Mr. A.R. Malhotra, Learned Counsel submits that the Learned First Appellate Court, in its judgment and order dated 2/2/2021, passed in RFA 26 of 2019, at paragraph number 6 of the judgment, clearly held that a will executed on the date averred would be governed by the Act of 1956. The said finding has not been challenged by the respondent by filing a cross appeal or separate appeal. Therefore, the same having attained finality, the respondent is only stopped from raising any objection at this stage. And Your Lordship had upheld my submission in para 21. Because, Your Lordship, the first appellate court had set aside the judgment of the trial court. But at the time of setting it aside, the first appellate court held the 1956 Act will apply for probating the will. But the first appellate court came to a decision that the will was void in accordance with the provisions of 56 Act. So that's why the trial court judgment was set aside. Now my learned friend did not challenge the,
Okay, so it held that 56 Act will apply.
yes,
But at the same time, which was probated, it is not in terms of 56 Act.
yes, yes.
That
It
is
did
why
not- it did not,
it reversed.
It did not fulfill the criteria laid down in 56 Act for a valid will. So that's why the appeal was allowed, the first appeal was allowed. And then my learned friend did not challenge the finding of the first appellate court with regard to the fact that the 56 Act will apply.
Okay. Let us revert to this paragraph 6. Is it available anywhere in this record?
Yes. In, page 81.
Page 81. Page 84, Your Lordship. Relevant page.
84.
If I may read it.
Yes.
From the averments in the probate petition, the will sought to be probated was executed on 15th August 2014. That is before the date the Mizo marriage Divorce and Inheritance Act 2014 came into force by Government of Mizoram notification number so-and-so dated 13th of February 2015. A will executed on the date averred would be governed by the Mizo District Inheritance of Property Act 1956. So it was a clear finding of the First Appellate Court that the will executed on 15/8/2014 would be governed by the 56 Act. Thereafter, Your Worship, the First Appellate Court had gone into the provisions of the 56 Act and had come to a finding that the will was not executed in accordance with the 56 Act. But this finding of the First Appellate Court at para 6 was never challenged by my learned friend.
So what was the grounds taken in the RSA? I mean, the substantial question.
This Honorable Court by a separate order, and then Your Lordship had come to this finding at para 21. So proper hearing was held on this point, and Your Lordship's finding is at page 21. In this regard, Your Lordship, I'd like to rely on 2013 2 SCC, page 320. 2013 8 SCC, page 320.
Which paragraph?
Page 333.
What is the paragraph?
Para 20 onwards.
Yes.
Para 20.1, Your Worship, when the review will be maintainable. I'll take Your Worship to para 20.2,
Yes.
when the review will not be maintainable. Number 1, 20.2.1, a repetition of old and overruled argument is not enough to reopen concluded adjudications. So, Your Worship, this argument was raised by my learned friend at the time of hearing of the appeal. And he is trying to reopen the same argument in a review petition. The learned Supreme Court has held a repetition of old and overruled argument is not enough to reopen concluded adjudication. Number 3, review proceedings cannot be equated with the original hearing of the case. Again, number 4, review is not maintainable unless the material error manifest on the face of the order undermines its soundness or results in miscarriage of justice. I'd like to rely on paragraph subclause 5. A review is by no means an appeal in disguise, whereby an erroneous decision is reheard and corrected, but lies only for patent error. Again, number 9. Review is not maintainable when the same relief sought at the time of arguing the main matter had been negative. So these points which my learned friend is trying to bring up at this stage in a review petition have already been raised by him during this appeal hearing, and they have been negative. So it is not possible for him to bring up these points in a review petition. It is very clear.
Okay.
And my learned friend had said that since the First Appellate Court's judgment was in his favor, there was no question of him filing an appeal against the judgment. But if I may take Your Lordship to Order 41, Rule 22, CPC. This is regarding filing of cross objection. Order 41, Rule 22.
Yes.
Upon hearing, respondent may object to decree as if he had preferred separate appeal. Any respondent, though he may not have appealed from any part of the decree, may not only support the decree, but may also state that the finding against him in the court below, in respect of any issue, ought to have been in his favor, and may also take any cross objection to the decree, which he could have taken by way of appeal, provided he has filed such objection in the appellate court within 1 month from the date of service on him or his pleader of notice of the day fixed for hearing the appeal. So
This is a cross objection or cross appeal?
cross objection.
A provision for cross objection?
Yes. So this provision was available to him if he was aggrieved by the finding of the First Appellate Court that the 56 Act will apply instead of the 14 Act. He could have preferred a cross objection on that point, because in this substantial question of law which was framed by this Honorable Court on his submission was that the 14 Act will apply and not the 56 Act. But that matter was already decided by the first appellate court, and he did not file any appeal against that. Even in the probate applications, Your Worship, in his written objection, he never took the plea that the probate application is liable to be dismissed as the will has to be executed in accordance with the 14 Act.
All right, so we'll come back to 2.
So, Your Worship, what I have stated is that the points which my learned friend has raised in this review petition were already raised by him before the appellate court, and they had been negative by the appellate court. So, as per the ruling of the Supreme Court in this 2013, volume 8, SCC page 320, para 20.1, para 20.2. So these arguments cannot be taken up again in this review petition. In fact, if I may take your lordship to page 333, which I have just read.
Yes.
Now, 20.2, when the review will not be maintainable, I'd like to lay stress on clause 1, subclause 1.
Mr. Malhotra, you have already read this.
Yes,
You don't have to repeat.
Yes.
1, then you had referred to 5, then you had referred to 9.
Yes. So these points having been raised by my learned friend during the appeal proceedings cannot be raised at this stage in a review petition. And my learned friend had also referred to Order 41 Rule 33.
Yes.
And those are parts of the appellate court, Your Lordship. The appeal has been disposed of. So now Your Lordship is exercising the review power under Order 47 Rule 1. Your Lordship is not exercising the powers of the appellate court. The appeal having been disposed of, and this being a review petition, and it has been filed under Order 47. So Your Lordship is exercising powers under Order 47. My learned friend should have referred to Order 41 Rule 33 at the time of hearing of the appeal, not at this stage. It appears he has missed the bus. So
That's Mr. Malhotra's favorite solution.
So that is the main point, Yash, because, and this ground which he has taken that it should be the 2014 Act which is applicable. It was raised by him, a substantial question of law was also framed, and Your Lordship had decided the substantial question of law in para 21 of the judgment. So my humble prayer, Your Lordship, is that the review petition deserves to be dismissed.
Any response?
Nothing, Your Lordship. Again, my review is very limited. I could not have filed the appeal because the appeal was decided in my favor and there would have been no cause of action. With that, I conclude my submission, Your Lordship. The rest I leave it to Your Lordship.
Please write down. Heard Mr. Lal Fakoma, learned counsel for the petitioner, and Mr. A.R. Malhotra, learned counsel for the respondent. Stop. This is a review petition filed by the petitioner seeking review of the judgment in order dated 13/8/2024 passed by this court in RSA number 2 of 2022. Stop. Mr. Alal Fakoma, Learned Counsel for the petitioner, submits that the main grounds for seeking the review of the said judgment and order is in respect of the first substantial question of law formulated by the by this court in the second appeal, which is as to whether the respondent as appellant, not being the legatee, can have the locus standi to file a petition to probate the will dated 15/8/2014, executed by one Srimati Van Leary, bracket late. Van Leary was your mother or grandmother?
I'm the executor.
Oh, I see. Who is she?
She was the,
She's not related to anyone.
She's my mother.
She's your mother.
Yes, and the granddaughter, the grandmother of the legatee, one of the legatee.
Who is the mother of the review petitioner?
grandmother of the other legatee
And the grandmother of the other legatee.
in the will.
And file the subsequent connected appeal in violation of the provisions of the Mizo Marriage, Divorce and Inheritance of Property Act, 2014. So the Learned Counsel submits that since RFA number 26 of 2019 was decided in favor of the review petitioner by judgment and order dated 2/2/2021, the petitioner has no reason to file an appeal challenging the same. Full stop. This court, on the other hand, write the judgment and order dated 13/8/2024 in RSA number 2 of 2022. Opine that the first appellate court's judgment had neither been challenged nor objected to by the petitioner at any point of time. And therefore, objections being raised by the review petitioner in the second appeal could not be entertained. This was the only point, isn't it?
Right.
The learned counsel therefore submits that the judgment and order dated 13/8/2024, so far as the conclusion reached at paragraph number 21 of the said judgment has to be recalled. Stop next para. Mr. A.R. Malhotra, learned counsel, on the other hand, submits that the ground raised by the petitioner had elaborately been considered by this court. And it was only thereafter that a conclusion has been arrived at. To stop, therefore, the instant petition being a review petition, the same cannot be filed in the guise of an appeal, and that the issue already considered and decided cannot be reopened under the review jurisdiction. Stop referring to paragraph number 8 of the judgment and order dated 13/8/2024, the learned counsel submits that the submission made on behalf of the appellant in the second appeal that according to the first appellate court, the will executed on the date averred will be governed by the Act of 1956 was accepted by this court while rendering the judgment and order dated 13/8/2024. To stop, he submits that such submission was advanced in view of paragraph number 6 of the judgment dated 2/2/2021 passed by the First Appellate Court in RFA number 26 of 2019, wherein it was clearly recorded that the will executed on the date averred will be governed by the Mizo District Inheritance of Property Act 1956, and the relevant provisions of which was also reflected, abstracted in the said judgment. To Stop. He therefore submits that the submissions advanced by the learned counsel for the review petitioner that he had no reason to challenge the judgment in order rendered by the first appellate court. Cannot be accepted. To stop. In fact, the review petitioner at the appropriate time could have availed the provision of Order 41, Rule 22, CPC, for filing cross-objection in the appeal filed by the respondent. Raising his grievance with regard to the application of the Act of 1956. For probating the will concerned. To stop such provision having not been availed of at this stage, the submissions made by the learned counsel cannot be accepted. To stop, insofar as the review jurisdiction is concerned, the learned counsel submits that the settled position of law is clear that you can say the settled position in law is that a repetition of old and overruled argument is not enough to reopen concluded adjudication, and that a review is by no means an appeal in disguise, whereby an erroneous decision is reheard and corrected. To stop. In fact, review lies only for patent error and not otherwise. In support of his submission, the learned counsel has relied upon the case of Kamlesh Verma versus Mayawati and others, reported in 2013, 8 SCC 320. Stop. Next para. The learned counsel further submits that insofar as the submission made by the learned counsel for a review petitioner in respect of Order 41, Rule 33, CPC is concerned, he submits that the same argument could have been made at the time when the first appeal was filed by the
Second appeal, Your Honor.
second appeal or first appeal?
Yeah, this is a review of the second appeal.
Oh, yes. At the time when the second appeal was by him, first appeal by him, your second appeal. At the time when second appeal was filed by the respondent, and not at the present stage, wherein a review petition has been filed. To stop. Therefore, the argument advanced does not hold any water, and the review petition should be dismissed. In the beginning part now, when Mr. Lal Fakoma's submission is concerned, you add this line. Mr. Lal Fakoma, learned counsel for the petitioner, further submits that Mr. Fakoma, Learned Counsel, by referring to Order 41, Rule 33, CPC, submits that the appellate court indeed has the power to pass any decree and make any order which ought to have been passed or made as the case may require. And this power can be exercised by the court, notwithstanding that the appeal is as to part only of the decree and may be exercised in favor of all or any of the respondents or the parties. To stop, he submits that the power can be exercised in respect of all or any of the decrees, although appeal may not have been filed against such decrees. To stop, the Learned Counsel submits that the petitioner may not have filed a separate appeal, but by invoking the aforesaid provision, the necessary adjudication can be done by the appellate court even at this stage. Next regular paragraph. I have heard the submissions made by the learned counsels for the rival parties and peruse the materials available on record. We'll stop. The grievance expressed mainly in the instant review petition is with regard to the finding arrived at by this court in respect of the first substantial question of law, wherein it was held that the decision of the first appellate court that the will executed on the date averred would be governed by the Act of 1956, which was not challenged or objected to by the respondent oblique review petitioner herein at any point of time. Stop. Reverting back to the judgment of the first appellate court, it may be seen that although the first appellate court came to a finding that the will could not have been probated in the absence of a executor. There was no executor.
No, the first appellate court.
Yes.
No, the first appellate court held that 56 Act will apply. But
Apart from that,
since the will was not executed as per the criteria given in 56 Act.
criteria.
Yes.
What is
because,
that criteria?
Two attesting witnesses.
Okay.
Like that.
Please repeat. Last line. In absence of the fulfillment of the criteria provided by the Act of 1956. Act of 1956 also held that the will that was executed on the averred date would be governed by the Mizo District Inheritance of Property Act 1956. Stop taking note of the same, as well as the submissions made by the learned counsel for the respondent herein. This court provides judgment and order dated 13/8/2024 in RSA number 2 of 2022 had concluded that the findings of the First Appellate Court in regard to the applicability of Act of 1956 had never been put to question by challenging the same through appropriate proceedings. Stop. Therefore, it is clear that the grounds raised by the petitioner in the instant review petition in this regard had duly been considered by this court, and therefore to once again undertake the exercise of reconsideration would mean that sitting an appeal over the earlier judgment rendered by the same court. Stop. The apex court in Kamlesh Vora, Supra, Kamlesh Verma, Supra, by relying upon, had relied upon the case of Union of India versus Sundar Manganese and Iron Ores Limited, reported in 2013, 8 SCC 337. Wherein certain principles were set out where a review will not be maintainable. Full stop. One of such principle was that review is not maintainable when the same relief sought at the time of arguing the main matter had been negatived. Stop. It also held that a repetition of old and overruled argument would not be enough to reopen the concluded adjudication. Full stop. Therefore, having regard to the projection made by the petitioner in the instant review petition, this court is of the considered view that the grounds so raised does not come within the ambit and scope of the review jurisdiction. Or conferred by Order 47. Is it Rule 1? Rule 1 of CPC. Stopping the result, the review petition is found to be without merit and same stands rejected.
Deeply obliged.
Admission item 3.
May I please, this matter is regarding the recommendation of the petitioner for promotion under the CAS scheme. Initially, it was recommended, and subsequently, a review committee was constituted, and the recommendation was cancelled.
CAS means Career Assurance
Yes.
Scheme.
This matter will take time, and
Well, we may not be able to finish today.
Okay.
if we can take it up tomorrow.
Well, tomorrow, if it is possible, let it be listed in the coming week, my lord. Next week.
Okay. When? Monday, Tuesday? When? You want a fixed date?
Yes, a fixed date may kindly be fixed.
17, my lord.
17th of Tuesday, as paid for by the parties. This is the matter for admission hearing on 17th of June.
Obliged.
Item 4.
May it please your lordship,
Yes.
although this matter was listed for admission hearing, your lordship, I would like to state that in our affidavit on behalf of the state respondents number 2 to 5, on pan number 7, your lordship, if I may read page number 4, your lordship.
Yes, what is there?
Your lordship, there was a request by the Under Secretary Land Revenue to the DC Kolasip to have a fresh assessment. So on that regard, your lordship, new developments have to be submitted before the court, your lordship.
So,
So if I may be allowed to file an additional affidavit, your lordship.
has it happened, new developments?
Yes, your lordship, as per my verbal instructions that I have received, I had inquired and they have told me that the new developments are in place and the documents will be sent to me at the earliest, your lordship. Your lordship,
Paragraph number
on pan number 7, your lordship.
7 of your counter affidavit.
Yes, your lordship.
Mr. Biagnu, what do you say?
Yes, let them file, my lord.
Okay, parties are represented by the respective councils. Stop at the outset. Ms. Lal Nunhui, learned government advocate, appearing for the state respondent, submits that she is awaiting further instructions in view of the stand taken at paragraph number 7 of the counter affidavit. She therefore submits that she may be given 2 weeks' time to receive instructions and to file additional counter affidavit if found necessary. No prayer is allowed.
Much obliged, your lordship.
Lordship, item 5. Lordship, I received counter affidavit from respondent number 1 to 3. So yesterday, so with due permission of this honorable court, I need to make a reply to that affidavit because there are subsequent development also. I need some issues also I need to address also. And I have been instructed that they're paying.
This morning you said something about lower court.
Yes, that's lordship.
See, just thought about it. In fact, it's not lower court.
Yes,
What Supreme Court has said was regarding subordinate courts.
yes, exactly.
He said, don't call them subordinate courts.
No,
But
but
low,
but
there was
recently-
nothing about low courts.
yeah, recently there has been judgment.
No, regarding lower courts or subordinate courts.
It is subordinate court, but we address lower court record LCR. So
No. See, every courts are functioning independently.
Yes,
Nobody has the power to direct a particular court to decide a matter in a particular way.
exactly, lordship.
So that's why the courts, the district courts are not subordinate courts. But regarding lower court records, I don't think there's any issue about it, because once we call the records, we say, let's call for the LCR.
LCR.
That's the common thing.
Yes.
We don't say that call the records, call for the subordinate court records.
Yeah,
We
yes.
say call for the lower court records.
But
Otherwise, you see, if you apply the same concept, then the high court, who is high court? Then that high part will be removed. Will be like court.
actually, lordship,
We are all courts.
allow me to furnish that judgment. Actually, it has been directed to furnish all,
Anyway,
all to
that's-
the high courts.
All right. You
I
may
was
furnish.
also a bit surprised because we keep calling LCR in the course list.
Okay.
It's fine.
Yes, you may supply that.
Yes, my lord.
So, coming back to this case, you want some time for the rejoinder.
Yes, lordship.
How much time should you require?
3 weeks, lordship.
3 weeks' time.
Yes.
What do you say, Mr.?
Then we may be given an opportunity to file an additional
Surely,
reply.
surely,
Because-
depending on,
Because after we go through the reply, there may be a need to file a rejoinder.
see, normally,
It may be, and it may not be also.
normally what happens is, once you file a petition, a writ petition, there's a counter. After the counter, if so required, the opposite party says, okay, give me an opportunity for rejoinder. Once rejoinder is filed, normally matter ends there, as far as pleadings are concerned. Only in exceptional cases, wherein certain issues are raised, which perhaps has to be countered, then court may permit. Otherwise, it'll be never ending.
It will be never ending.
5 affidavits from here, 5 affidavits from here. Otherwise, ultimately, you have a paper book which
No,
is
if
sort-
it is required,
All right.
if it is required, the respondents will file a rejoinder. So 2 weeks may be granted.
Let them file. Let them file, and once they file, you go through it, and if you find that you have to reply, then the prayer may be renewed. At this stage, I don't think there's any requirement of giving advance in advance.
No, at least the option may be given to the state respondents to file a rejoinder to the reply which they are going to file.
So that's in anticipation. And again, Mr. JC will say, also give me another opportunity
No,
for.
but then at that particular moment, whether it will
All
be
right.
allowed or not, that may be recorded.
All right, we'll do it this way.
That may be recorded.
All right, we'll do it this way then. We'll allow,
And in the meantime, my lord, 1 minute. And in the meantime, my lord, the interim order is also there.
That needs to be extended, Your Lordship.
So
yes, you'll have to.
I am
extend
praying
it.
for hearing of that particular part at least, whether the interim order can be
You could have very well filed an application for vacation of the
Vacate.
interim order. We could have heard it. But now, there's no such kind of application. And you have received a counter affidavit, and petitioner will have that
Your Lordship,
option of filing a rejoinder if he wants.
I'm appearing on behalf of the respondent number 5. I'd like
Yes.
to make submission in respect of the interim order. If it is not
Oral
to be-
submission. Why don't
Yes,
you make a written submission
Submission, yes.
by filing an affidavit for vacation or whatever, and then
Lordship,
we hear
the
that.
interim order continues only till today.
I understand.
Yes. So if it is to be extended, at least there has to be some application to that effect. But there is no application for that. So the question of extension will not arise at this stage.
Why do we need an application for extension?
There is no requirement for extension of the stay order.
Why? Why is that? What was the stay order?
My lord, that
Lordship,
floor
the stay
test, which has to be conducted on 16th.
At para 10 of Lordship's order, it is stated, having regard to the fact that floor test in respect of respondent number 5 is scheduled to be held on 16/5/2025. And at the same time, considering the fact that the respondent number 5 was appointed on 2/5/2025, on which date the appointment of the petitioner subsisted as the CM LADC, it is hereby directed that until the next returnable date, the impugned notification dated 8/5/2025 shall remain state. At this stage, Your Lordship may make submission to the effect that the notification dated 8/5/2025 is not at all impugned. It is not part of the impugned notifications. Lordship, if I may take, Your Lordship, to the prayer portion at page 57.
Mr. Ramzawa, have you filed a counter affidavit?
We have not filed.
Why don't you file that?
We'll file it, Your Lordship. But at this stage,
We'll thrash out the issue
yes.
once the pleadings are complete. If your parties agree.
There is urgency in this case. We have not filed a counter,
so you
but
file.
we have not been given a copy of that affidavit of the state also.
You'll
We-
get it.
No, you have entered appearance only today.
No, not only me, my colleague, Mr. Jordan.
You will get everything.
Yes.
Everyone will get a copy. Please file your pleadings, and we'll fix a date. And till the next date, I think we should continue with this interim.
In the meantime, Your Lordship, if I take a Lordship to the prayer portion, A is at page 57, Lordship.
Yes.
The prayer is that for a direction and order from this honorable court against the respondents
for quashing or setting aside impugned notification dated 2/5/2025, notification dated 7/5/2025, along with its connected communications dated 2/5 and 5/5/2025. B, for stay of the operation of impugned notification 2/5 dated 2/5/2025 and its subsequent correspondences 7/5/2025 by Secretary DC and MA. Notification dated 8/5/2025 by Additional Secretary. This is what I'm talking about.
Yes.
This notification is never impugned. It has been mentioned only at one portion of the petition. Even at that stage, it has not been impugned.
My lord, if you read para 35 of my writ petition, I have impugned, I have specifically stated that how I have been impugned, and very clearly. And if they want to vacate, they can file IA for vacating this interim order, Your Lordship, and they file counter affidavit also. Para 35.
All right, how soon can you file your rejoinder? How soon can you file your rejoinder?
My lord, 2 weeks.
Lordship,
And they have not filed counter also by the respondent number 6.
That we have already noticed.
the question of vacating the stay order will not arise at this stage because it continues only till today. We are talking about whether the stay will extend or not.
But Lordship, the practice we follow here is that normally interim order has been extended in the next court date, depending on the fact and circumstances of the case.
If I take a Lordship to para 29, para 29, this is where they have stated about the
Anyway, Mr. Ramzawa, you file your affidavit.
will file.
We'll,
Yes,
we'll,
Lordship.
we'll take a call. As soon as all of you file your pleadings and all these issues will be resolved. But so far, as of today's concern, let it continue. We'll fix a date.
Lordship,
The matter may be heard after the pleadings are over.
Exactly.
stay is not an interim prayer. It is one of the main prayers.
Rightly or wrongly, we
But
have
if
granted
there
it.
is no stay, the very
Rightly
part
or
of
wrongly,
It
or
is
this way or
made-
that way, we have granted that stay or that
When a stay
interim
is
order.
granted, Your Lordship, it means the very prayer of the writ petition that has been granted.
No, not at all.
Stay is the main component of the prayer.
No, my lord.
They have challenged the validity of the notifications dated 2/5 and 7/5, not 8/5.
All right. You file your affidavit, we'll see.
And under given circumstance, Your Lordship, since there is urgency in the matter, we'll have to file our affidavit within a period of 2 weeks.
Exactly. 2 weeks,
Then-
after 2 weeks, we fix a date. If you all agree to a date, we'll have a date.
Lordship.
So there's some certainty.
My lord, even what about respondent number
Because
5?
Mr. Dev
Res-
is also coming from Cal.
My lord, what about respondent number 4? That is LADC, they are not filing or?
It's up to them if they don't want to file. We can't force them to file. We have it on 24th?
24th June.
Yes.
24th or 25th?
25th June, yes.
25th
Which is
Wednesday.
convenient. Please write down, Mr. J.C. London Sang, a learned counsel, appears for the petitioner and submits that he has received a copy of the counter affidavit filed by the state respondents and prays that he may be given 2 weeks' time to go through the same and file a rejoinder, if so advised. We'll stop. Mr. Bishojit Dev, learned advocate general, appears for the state and submits that liberty may be granted to the state for filing additional counter affidavit against the rejoinder to be filed by the petitioner. Full stop. Mr. Sheila Ramzawa, Learned Senior Counsel, assisted by Mr. Jordan Romhitanga, appears for the respondent number 5 and submits that he may also be granted 2 weeks' time to file counter affidavit. Then you are there also?
Yes, my lord. For respondent number 4.
Your good name?
Arlan Musiama.
Mr. Arlan Munsiama, Learned Counsel, appears for the respondent number 4. You will be filing anything
Yes, my lord.
and has a similar prayer for filing counter affidavit. Full stop. Next para. In view of above, and has agreed to let the matter be listed on 25th of June 2025. 25th.
Your Lordships may also.
Will liberty be given to the state respondents to file counter?
No, it is reflected.
The state's counter may also be.
I've recorded your submissions, but what I'm going to say is something else.
My lord, the state's counter may also be provided to the other respondents.
Surely, surely. That though, in view of above and as agreed to by the parties, let's list the matter on 25th of June 2025. Respondents, apart from the state respondents, to file their counter affidavit on or before 24th of June. Stop. Similarly, the petitioner shall also file the rejoinder affidavit on or before 24th of June. Stop. Liberty is also granted to the state to renew their prayer for filing additional counter affidavit against the rejoinder affidavit to be filed, depending on the requirement to file the same. All right, that'll remain. In case you raise something, like something way out, then they'll be taken by surprise. They say, let me counter for that. So that option may be there.
Option may be given.
If it's nothing new is there, then of course it may not require also. So that, and regarding copies, I think I'll not record anything. You can, Ms. Mary, you make sure that you give a copy of the counter affidavit to the parties concerned, okay? And till the next date, interim order passed earlier shall continue.
My lord, may I please pray for maintaining status quo if your lordship permits?
What status quo?
As of today, my lord, there has been some steps have been taken still.
Maybe, but we cannot change that thing at this stage. Whatever was directed that day will remain.
As actually,
Till
your
the next
lordship, you mentioned that something new things might rise up that one, because now we heard that there are some steps also still indirectly violating.
So you are at liberty to file appropriate application saying that this has happened, that has happened,
Yeah,
so
it's-
this order may be modified
Yes.
to that extent.
Exactly.
Without
that's why-
that, you see, we cannot just orally,
That's,
because they
that's
also
true.
will say orally vacated.
That's true, your lordship.
Then if I accept your oral prayer, I'll have to accept their oral prayer.
Yes,
Ultimately, pleadings will go only, oral pleadings will be there.
yes, lordship, that's true. Much
All
obliged.
right.
Item 6.
My lord, I received instruction by telephonic information by stating that the proposal is under consideration for payment. Then I may be granted 3 weeks' time for finalization, my lord.
Where is that proposal?
My lord, I just received telephonic information. Then that should be followed by official letter later on, my lord.
Well, give it in writing. Why don't you give it in writing?
Yes, my lord. A week time may be given for...
1 week, you file an affidavit that we are considering for payment. Then we'll see what is to be done, okay? Mr. Vanal Learned Counsel appears for the petitioners, and Ms. Zainam Sangpui, Learned CGC, appears for the respondent.
1, 3, 5, 7, and 8.
Numbers 1, 3, 5, 7, and 8. Mr. Bilal Ramenga, Learned Counsel, appears for
4 and 6,
respondent numbers 4 and 6. Stop. Ms. Zaram Sangpui, Learned CGC, summons that she has received telephonic instructions that the necessary process is being taken for payment of the compensation amount to the petitioners. So, considering the submission made, let an affidavit be filed within 1 week regarding the status of payment of compensation by the respondent number. Who will file? One of them, any one of them can file.
Any one of the respondent,
8, come on.
it may be 8, my lord, respondent.
By the respondent number 8. All right. You just have to get something in writing and incorporate it
lord.
in affidavit and file it.
Yes, my lord.
We'll take it on record. List again after a week. All right.
Obliged.
Item 7. May I please lodge?
Yes.
My lord, the counsel leading this matter unfortunately is unable to make it today due to an unforeseen natural calamity at his residence, my lord.
Who?
J.H. Ricky, Nilrod Fella.
Okay. It's item 7, is it? But where is his name? His name is not there. Oh, it's in the second page.
Next page.
Lordship, J.S. Ricky has been appearing on behalf of the respondents and even the opposite parties 1 and 2 in connection with IA Civil 76 of 2025. Lordship, today has been fixed as per his convenience. If it cannot be taken up today, Lordship may fix it for tomorrow.
Yes, when can he come?
My lord, if it may be taken up next week, since the mishap has caused a hazardous situation for the neighbor, the landslide has caused some hazard to the downstairs neighbor. So, if time may be granted till next week.
He was telling it even the previous week when he was filing this affidavit in opposition. He said, Monday will not be convenient, let it be fixed on Tuesday. That's what he said. We have not heard of any such hazardous condition. There was some landslide around his residence. That's what we heard.
Mr. Ramzao, I think we should consider that because nowadays you see everyone's having problem. Even in my locality, in my own house, my neighbors, they have a landslide and it has affected us. And we were in a quite dilemma on Sunday, whether to go elsewhere or remain, something like that. So this situation is like that. We have it on Tuesday again, coming Tuesday?
Let it come on Monday.
Monday?
Yes,
we
ma'am.
agree to that?
Yes, ma'am.
All right. Although Mr. Sheila Namzawa, Learned Senior Counsel for the appellants, is present, Mr. J.H. Ricky, Nalwat Fela, Learned Counsel for the respondent number 1 and 2, is absent, and a mention is made on his behalf to the effect that he has some personal difficulties to appear before the court. Full stop. On a prayer made on his behalf, the matter stands adjourned to be listed again on
16th.
16th of June 2025.
Obliged.
Item 8.
Your Lordship, we received the paper book from the registry.
So we fix it for hearing?
Yes, the earlier order passed didn't mention anything about admission of the criminal appeal.
Is it so?
Yes, this is, in fact, this is jail appeal.
Mr. Bilal Ramena, learned amicus curiae, appears for the appellant, while Ms. Van Mesiami, learned additional PP, appears for the state. Stop. The learned counsel submit that they have received the paper book and the matter may be listed for hearing. Stop. It is seen that the appeal has not been admitted yet, and therefore the appeal is admitted to be heard. Registry to list the case for hearing as per its own turn.
Much obliged.
Part 2, item 1 and 2.
After a week, these matters may come up after a week.
What are these matters? Slapped together.
The petitioners are working on contract basis in Ripans. And in fact, some of them have been working for more than 20 years now.
So what is happening?
Now, Your Worship, the Union of India took a decision that the contract period should not be renewed, and they should be outsourced through the GEM. It's called GEM. It's a portal run by the, I think, central government, where services are outsourced. So decision has been taken by the Union of India that contractual services should be terminated and the services should be outsourced.
What kind of position are they holding?
The
technicians?
No, there are some lecturers also, professors also.
Professors also.
Yeah. And cooks, security guard, number of them.
Contract basis?
On contract basis. The problem is, when initially when they were appointed on contract basis, there were no sanctioned posts. But because of the need of the situation at that time, they were appointed on contract basis. Because early on, it was the Ripans was offering only diploma courses. Then they started offering degree courses, postgraduate courses. And according to the AICT and different institutions, they had to have a set number of staff. So
Ripans is under which ministry?
Health and Family
Yes,
Welfare.
Ministry of Health and Family Welfare, my lord.
So in spite of
you are for the Ripans?
I'm the standing counsel, yes, my lord.
Ripans. And even ministry is also
yes.
there?
Yeah. Union of India.
What do they say?
They are the ones who took the decision that the contract services should be terminated. But in spite of the decision now, Your Worship, they have again made advertisements for contract employment. But this time, I think it's against sanctioned posts.
Yes, my lord, that has to be clarified as per the direction of this honorable government on the last occasion, and I have filed additional affidavit, wherein I had stated that as per the instruction I received, this is in particularly for 100-bedded hospital, which is to be established in Ripans, and this is the sanctioned post already. So it has nothing to do with the present post. That is what they said.
But the principle will apply, Your Worship. I mean, we are all working under Ripans. Now, the Union of India is, I think, planning to open a 100-bedded hospital in Ripans. And for that, posts have been sanctioned. And instead of recruiting on regular basis, they're going for contract appointments. So now, once in our case, we have been working there for the last 20 years. They say that contract employment should be terminated. But now with the new hospital which is being set up, they are again opting for contract employment. I mean, is that possible? We are all under the same ministry, we're all under ribbons. For one set of employees, they say that no, contract employment is not possible. Another set of employees, they're saying yes, we'll take them on contract basis. And that is very arbitrary.
That is only for particular hospital which is to be served by the ministry.
It is still under
That is
ribbons,
what
it
they
is
say.
still under the same ministry.
Okay, anyway, so it'll have to be heard then.
Yes. And moreover, my lord, the present petition have been working till today under the protection, interim protection of this honorable court since 2020.
During COVID times, Your Worship.
Yes.
And lots of time was sort of lost due to COVID. And Your Worship, that famous ruling of the Supreme Court in Piara Singh, one set of temporary employees cannot be replaced by another set of temporary employees.
You'll be taking out that.
Yes. That's what they're trying to do.
Okay, when do you want it?
After a week, my lord.
After
All right. As wait for by the parties, list the matter after a week.
Much obliged.
Any ready cases for today in the hearing section?
I don't think, my lord, I don't think.
All right, let it remain in case somebody is interested tomorrow.